duties, fiduciary relationships, accessory liability for lenders, and the remedy of rescission. So I'll start with a few words from the People's Chancellor, Martin Lewis, of the Money Saving Expert website, commenting on the scope of the Court of Appeal decision, which is being challenged before the Supreme Court, obviously. And bear in mind at this point that his Money Saving Expert website has resulted in over 2.5 million complaints being logged via his online tool. And he says, it's a push, even for me, and may risk being counterproductive to consumers, as it is a potentially existential threat to consumer lending and could mean less availability and higher costs in future. And you may follow that with a question, which is Money Saving Expert potentially caught by the judgment? And we'll come back to that in due course. But turning firstly to a quick recap on the basics, a consumer wants a car, they go to a car dealership. Like the estimated 90% of the UK population, they need or want car finance to make the purchase. The dealer arranges finance with the lender. The car is then sold to the customer on finance. The consumer enters a finance agreement with the lender, and the agreement shows them all of the prescribed terms which are required by the UK's truth in lending laws under the Consumer Credit Act and its regulations, such as the APR, the interest rate, how much they're borrowing and for how long, and how they make repayments. So the deal is done. The customer leaves the dealership with the car and pays the finance company in installments. And the lender pays the dealer for the car, and in these cases, they also pay them a commission for selling the finance. So what went wrong? Well, the issue began with the use of so-called discretionary commission arrangements. Those are the arrangements which effectively allow a broker to earn more commission if the customer is charged a higher rate of interest. So higher interest, more money for the dealer. And the FCA intervened and banned such discretionary commission arrangements in the motor commission sector in January 2021. And of course, this made the issue low-hanging fruit for claims management companies who were dealing with the dregs of the PPI litigation by this point. And of course, a knee-jerk reaction to this, well, is that it's terrible. The customer's being ripped off if the dealer could make them pay more for the finance. But there are commercial justifications for discretionary commission models. And the main one is that motor deals are multifaceted, and allowing the dealer an element of discretion allows them to mold the deal as best fits the circumstances on the day. So, for example, some dealers will make no money on the car itself. They will make all their money on the commission. And some dealers may be dealing with a shortfall on a part exchange, for example, which will block the deal going ahead unless they can make some extra money on the commission and lower the price of the car in order to make the books balance, if you like. But the issue, as always, is one of transparency. And so what did the Court of Appeal find? Well, they found effectively that such payments were secret or half-secret commissions paid by the lender to the dealer, and that is not okay, because the dealer owed a duty to the consumer not to surreptitiously make a profit at the customer's expense. And the reason for that is because the dealer is the agent and fiduciary of the consumer. The lender has primary liability if there's a bribe because it's secret commission. If there's been partial disclosure, then the lender has secondary or accessory liability. And they also found in the case of Johnson that the lender was also liable under Section 140A of the Consumer Credit Act for an unfair relationship arising out of the credit agreement. Significantly, the Court of Appeal rationale did not depend on the type of commission being paid. And again, the concerns here arose because of a fear that the link between rate and risk was being broken. So my credit risk might be minimal, but I might be paying a higher rate of interest on the day because the dealer decided he wanted to make a bit more money out of me. And that was one of the concerns of the FCA, and the other one was that these deals could be anti-competitive. But the Court of Appeal don't go there in that sense. They are dealing mostly with the common law and fiduciary and disinterested duties. And so that is one explanation as to why the FCA concerns are not necessarily reflected in the Court of Appeal judgment. But there are 6 main issues, particularly novel points, I would say, arising for the Court of Appeal judgment. The first is secrecy. And that is the finding that in order to negate secrecy, commission disclosure has to be drawn to a customer's attention, and in particular, that a term in a signed contract that discloses the possibility of commission is inadequate to negate secrecy. That is arguably a significant departure from the well-established principle that one is taken to understand the contents of a document that one has signed. And so in that sense, was probably the most surprising aspect of the decision to some. The second point is the imposition of the duties in this case, both the disinterested duty and the fiduciary duty. The findings here that a retailer that brokers finance as an adjunct to selling goods, simply because they've undertaken to act as a broker, raise serious questions on the scope of the judgment. Are all retailers and anyone who gets commission affected? Again, back to the where we started with money saving expert and the like. The third point is the scope of the disclosure raised by the judgment. So the finding again is that disclosure above and beyond that required by the regulatory regime was required. So we had the regulatory rules in conc. The industry generally was understood what was required by those, although there's arguments about what they in fact require, but it was clear in broad terms what was required in that sense, both at the time of the transactions and as recently amended following the ban. But the decision again is much wider and goes well beyond that regulatory scope. The fourth point that is quite novel here is in relation to dishonesty and the finding that the lender had dishonestly assisted in procuring a breach of fiduciary duty, notwithstanding the fact that the lender has nothing to do with the lending for the most part other than providing the money. It's an arm's length transaction, and the imposition of contractual obligations on the broker by the lender is commonplace. So in the lender-broker agreement, they will usually require the broker to disclose the commission to the customer. And notwithstanding those facts, there was a finding of dishonesty made, giving rise to accessory liability. The fifth point that is novel is the finding that a commission of 25% was very high, in the words of the Court of Appeal. Again, that is arguably a significant departure from the tipping point, now infamous tipping point following the case of Pleven. And of course, we know the FCA used a 50% tipping point in the context of PPI commissions. And these are not PPI commissions. In the PPI case, Mrs. Pleven was effectively buying a commission because 72% of the price of her premium was commission. Here it is not the case that any part of the price of the car is made up of commission. And last but not least, the sixth novel point, in my view, is the fact that all commissions are affected, and the judgment has opened up the disputes to also fixed commissions. So not just discretionary commissions where the broker can earn more money if they like, but if the broker has no discretion whatsoever and simply gets what they're given under the terms of the agreement with the lender, then this is now also problematic. We know that the FCA didn't like the discretionary model and the fact that the middleman had a hand in setting the level of its own commission. and it was considered that that was a model that was capable of abuse. And as I said a moment ago, considered to be anti-competitive and risking breaking the link between risk and rate. But actually, the FCA, in fact, found that 44% of customers would be worse off as a result of the ban on discretionary commissions. And so it has never been the case that all discretionary commissions would operate to the detriment of consumers. But as I said, the Court of Appeal had no regard to different commission models because, again, here we're focusing on duties largely and perhaps not unfair relationships, which was very much the tail end of the judgment. So in terms of the extent of the decision, it is seismic that this could apply to all commissions. One only has to look at, for example, again, the Money Saving Expert forum on this to see people saying, oh, should I apply? I can't remember what the registration of my car was now. It's been so long ago, and I've been told I can't apply because it's a fixed commission, but actually now, presumably that's not the case, and very many discussions along those lines. And so if it hasn't happened already, the explosion is going to be even bigger than was first thought. Unless, of course, the Supreme Court changed things. So how will the extent of the decision impact the industry? Well, again, as I said a moment ago, there's some consternation here about the extent of the disclosure required, and there's been a lot of scrambling around by businesses recently who are attempting to react to the judgment in advance of the Supreme Court. And again, that's not unusual. Of course, the market moves before the courts do in almost all cases. And so very many businesses have already changed their disclosures. And so in some ways, unless the Supreme Court says something fundamentally different, the disclosure has already moved on, and for the future is likely to be more extensive than anything we've seen in the past. And so who does it apply to? Well, as I said a moment ago, query whether this is confined just to motor commissions and the motor industry. And again, just to bring us back to the forum style discussions that are going on here, I quote again from the expert website, which says, while slightly off topic, who else is thinking that all the insurance comparison sites and insurance companies will be the next target? As we all know, there's a kickback commission, which we are never told. This whole claim, simply because you were never told how much the finance company was paying the salesperson, is a joke. And the reply is, the consequences potentially extend to all manner of business activities. Not sure why you're picking on insurance, though, given credit cards, loans, mortgages, etc., which can be compared by the same websites, also get commission on leads that result in a sale, and so on. And so there's really, in some ways, limitless scope to this judgment where commissions are concerned. And as we know, commissions are the lifeblood of the retail industry. In terms of how businesses proceed then, well, for the back book, there will be all sorts of questions surrounding due diligence and securitizations, warranties, buybacks, extra due diligence to determine exposure in relation to portfolios of loans. And for news business, as I said a moment ago, a rush to adapt disclosure requirements, which many businesses have already done. So breaking down the decision, I'll turn now to have a quick look at each element of the decision and the takeaways from the Court of Appeal and give a brief view on whether, in fact, they may have gone too far. It's worth remembering, firstly, that the context of these decisions is that all three consumers were of modest means, and the cars purchased were all under £10,000. And so that does not help the factual assessment in terms of variety, because of course we know that not all consumers are vulnerable. And indeed, arguably, not all of these consumers were vulnerable. But that is the context in which this case was conducted. So the first aspect is secrecy. And here, the Court of Appeal found that for the lender to be a primary wrongdoer, the commission must be secret. So what is secret? Well, there was no disclosure at all in the case of Hopcroft. That was fairly uncontroversially secret. But controversially, however, there was said to be insufficient disclosure in the case of Wrench. And Wrench was the case which had the clause in the terms and conditions that commission may be payable by us to the broker who introduced the transaction. The amount is available from the broker on request. And this really drives a cart and horse through the idea that a person is taken to be aware of the contents of a document that they have signed. The Court of Appeal said disclosure in this context means taking reasonable steps to ensure that the fact actually comes to the attention of the consumer in a way which makes its significance apparent. This drawing to attention argument arguably comes from the case of Wood and paragraph 120 of Wood, but that case dealt with drawing to attention in a very different context that doesn't read across to the motor commission scenario. So Wood was referring to whether there was a duty if such a term was included. It was not dealing with whether the inclusion of such a term negated secrecy. And so that drawing to attention argument is arguably taken out of context. And that was a point that the judges in some of the lower courts made in relation to that argument. But Wood and paragraph 120 of Wood isn't referenced by the Court of Appeal. They simply say drawing to attention is a relevant factor, it's not decisive, and then they go on to say a person cannot claim that something was secret if it's clearly and openly conveyed in a document that a person deliberately doesn't read. If the document is designed for that purpose, they are directed to read it and they signed it. But in Wrench, they said the clause was hidden in plain sight and there was no real expectation that the customer would read it. And the question was whether enough was done to bring the salient facts to the attention of the borrower in a way which made its significance apparent. That is arguably, again, misconceived insofar as, again, it can be read back to Wood, because in that context, the Court of Appeal are discussing whether the fact that the presence of a term referencing the possibility of commission is not fatal to a finding of secrecy. But Wood was a completely different set of facts. The only real conclusion in Wood, and the proper conclusion construing the documents, is that there would be no commission. Wood didn't stop at simply saying there may be commission. It went on to say, we will tell you if there is in the circumstances in that case, and they hadn't. Ergo, the natural conclusion is no commission. That is not the position in Wrench. So clearly, again, if you're looking at this in the interim, then you're going to be looking for, do you have a document designed for the purposes of disclosure? Does it clearly and openly convey that there's commission? Does the customer, are they directed at least to read it? Do they sign it? Is it buried in the small print? Does it refer to a broker in the way which is understood by a customer? And does it deal with every relevant aspect that they might need to know about why and how the commission is being paid? So again, the salient facts brought to their attention in a way which makes the significance apparent. But this part of the decision, I think, is probably one of the most vulnerable aspects of it, because none of the bribery cases relied upon concerned cases where disclosure was made in the contract signed. And so in this respect, I think the Court of Appeal probably did go too far. And to put it more colloquially, and again in the words of another forum user, this is the weird bit of the ruling. Effectively, the court has said you can sign contracts and not be held to them because no one bothers reading them before signing them. So moving on, if there is no disclosure, however, which was the case in Hopcroft, then, and indeed a lot of the older cases where there was no disclosure at all, because it predates the Conk rules, then the question is whether there is a disinterested duty so as to engage the law of bribery. So here, this is the duty to provide information, advice, or recommendation on an impartial or disinterested basis, also known as the Wood duty. The Court of Appeal said in this context, the consumer relies on the broker to obtain an offer from a panel. The customer doesn't have access to the panel, only the dealer does. However, if the broker is purely an intermediary and there's no other means of remuneration, then one might reasonably assume that if the customer is not paying them, somebody else will be, i.e. the other party. But in these cases, the finance was an adjunct to the sale transaction. The customer would believe that the profit was being made on the car and not on the finance. And so they go on to say that they were all acting as brokers, a role they undertook on behalf of the claimants. And then crucially at paragraph 87, it's the very nature of the duties which the credit broker undertook which gave rise to the disinterested duty, unless the broker made it clear that they couldn't act impartially because they had a financial incentive. This is arguably where the Court of Appeal went wrong, because what is the role that was undertaken by the dealer? In most cases, one would think they're acting as an intermediary and nothing more. And that doesn't necessarily mean that they have undertaken any role on behalf of one party or the other. And indeed, one thinks back to the House of Lords case of Brown, White and Worcester Works Finance, that there is no need to impute an agency to a finance company in this scenario. A motor dealer is usually an independent trader acting on their own behalf, and so one simply doesn't need to consider that they're an agent on behalf of one party or the other. They're acting for themselves. And so here we also had the Court of Appeal say that it's the duty to be honest and impartial that matters. Well, honest is fine, of course, whatever one thinks of secondhand car dealers, but impartial, well, why? They're selling something. They're on the opposite ends of a commercial transaction. And so a recurrent theme here is really entitlement. Where does the entitlement to impartiality come from? And at paragraph 96, the Court of Appeal said, well, conc, and specifically the rule on commission disclosures at 4.5.3 is premised on a broker's duty to be impartial. Again, that is arguably not the case, and it's simply a requirement to disclose the commission where the impartiality may be affected. That in itself is arguably a recognition of the fact that there is no duty of impartiality. There is only a duty of disclosure where impartiality is affected. So did they go too far here? Well, there's no real principled analysis of why the disinterested duty arises. Arguably, too much reliance is placed on the mortgage commission cases. Because one goes to a mortgage broker for advice and generally pays for that advice, whereas of course one doesn't go to a car dealer looking for financial advice and doesn't pay for it. Again, here what we have is two parties effectively on the opposite ends of a commercial transaction, and indeed the Court of Appeal judgment does contradict itself in a number of instances on the customer's understanding of this. On the one hand, it says that the customer would clearly view this as one transaction, but then a lot of its rationale for imposing duties is that effectively you can divorce the sale of the car from the sale of the finance. But the point is that there must be something express or implied from which one can derive this entitlement. And so where there's an express contractual undertaking, for example, in many of the mortgage cases, well, one can see that, of course, the entitlement comes from the contractual undertaking. But in the absence of any express contractual undertaking, there may be other features from which an entitlement may be derived, such as payment, or being an obvious one, or indeed oral undertakings, depending on the circumstances. But But, for example, in the case of Hopcroft, there was neither an express undertaking to act nor anything concrete from which the entitlement should be implied, such as payment. She simply assumed that she would get the best deal. That is the height of the evidence in her regard. And so, whilst we might get into arguments in cases where there are documents stating what a broker will do, and how those documents should be construed, and there may also be arguments about what was said on the day, it's probably too far to infer a duty based merely on a role as an intermediary without more. And if the Court of Appeal are right, of course, the ramifications will be felt far beyond the motor sector. And indeed, in this regard, it's worth noting that the Court of Appeal themselves acknowledged that the language of bribery and fraud do not sit easily with the type of scenario with which the present cases are concerned. And so the Supreme Court in due course will hear argument that there is no disinterested duty distinct from a fiduciary duty. And indeed, it certainly seems that the Court of Appeal have conflated the two. At paragraph 91, they talk about the loyalty inherent in the disinterested duty, which again is conceptually difficult if the two are different, because disinterested, one would associate with impartiality, whereas loyalty, on the other hand, tends to connote partiality and acting in someone's interest. So moving on from bribery then, what if it's not secret and there's partial disclosure? These are the half-secret commission cases, or the partial disclosure cases, as the Court of Appeal called them. Here it's the Court of Appeal found that a fiduciary duty is required if it's half-secret. And that must be right, following on from Wood. And so here the lender is an accessory to a breach of fiduciary only. It's a secondary liability subject to knowledge and dishonesty. The Court of Appeal found that at paragraph 91, there was an ad hoc fiduciary duty running in tandem with the disinterested duty, arising from the nature of the relationship, the tasks with which the brokers were entrusted, and the obligation of loyalty inherent in the disinterested duty. The task was to search for and offer the customer a finance deal from the panel of lenders which was suitable for their needs and competitive. Again, pausing there, the task may be to search for and offer a deal, but why is it one that is competitive? In some cases, the Court of Appeal say they undertook to find the best deal, or the one which was most suitable. They therefore owed the disinterested duty. The relationship was also a fiduciary one. And here they again, reliance was heavily placed on the mortgage cases, and in particular McWilliam, when they said that this case was indistinguishable from McWilliam. And McWilliam was the low watermark for the mortgage cases, and indeed was one where there was no adversarial argument before the Court of Appeal, who considered and mentioned very early on in the judgment that it was not a vehicle for the decision of issues of principle. But in any event, in McWilliam, the customer paid £750 to their mortgage advisor for the purposes of independent mortgage advice, which is at the very least distinguishable on that basis. Similarly, the Court of Appeal said the fact that the finance was offered as a take it or leave it didn't matter, because it was expressly or by implication put forward as the most suitable. But if it's take it or leave it, how is that implying that it's competitive? So again, not easy conclusions to draw. Similarly, the Court of Appeal went on to say these relatively financially unsophisticated individuals undoubtedly placed trust and confidence in the brokers. But again, the test here ought to have been objective. It doesn't matter whether a person in the subjectively places their trust and confidence. The issue is whether objectively they should be entitled to do that because of the circumstances of the case. The Court of Appeal then went on to consider a number of reasons which had been used in other cases and to distinguish those as to why there was no problem with imposing a duty here. So they said, firstly, that His Honour Judge Worcester's analysis in relation to there being a role in the decision-making process was wrong, but not specifically why it was wrong. So His Honour Judge Worcester had said, well, then they don't have a role in the decision-making process. Here, a car dealer is simply putting forward options. So those options may affect what the customer decides, but the dealer doesn't have a role in the customer's decision-making process. But the Court of Appeal said, no, this is more like Wood. They don't just randomly source a lender. The lender is selected based on what the customer is looking for and necessarily involves the exercise of judgment. But again, Wood was a very different case where there was a questionnaire as to what the customer was looking for, advice, payment, and a follow-up advice in writing was supposed to be provided. Again, factually very, very different. And one can see the force in the arguments of His Honour Judge Worcester that, in fact, here all that's being done is, in most cases, a take it or leave it option is being put forward. Similarly, the Court of Appeal were anxious to say that the absence of payment of a fee was not an essential ingredient. And again, that's obviously right. And they mentioned the fact that in Wood there was a waiver of a fee in one of the cases. But again, in my view, that misses the point, because a waiver of a fee doesn't affect the fact of the underlying contractual obligation to advise in Wood. And indeed, there were 3 contracts in Wood and 2 fees were paid and one of them wasn't. Again, the point is the entitlement has to come from somewhere. And then last but not least, they also dismissed the 2 hats analysis, and this emanated from His Honour Judge Jarman in the Johnson case, which is effectively that, of course, there can't be a fiduciary duty because they're wearing 2 hats. They're selling a car on the one hand and selling finance on the other, and you can't divorce the 2. And here the Court of Appeal basically said, well, you can. It's in both of their interests to get affordable finance, so their interests are aligned. And these are separate roles. Selling the car and selling the finance are 2 independent commercial roles, which again is artificial in my view, because the car dealer, one doesn't dissect the transaction in that way. The car dealer's interest is in making a profit, full stop, on the transaction. And that profit may emanate from the car or the metal, as they say in the trade, or it may emanate from the finance. And indeed, some car dealers run business models where they don't make any money on the metal and they make their money on the commission. Or the profit may come from both the car and the finance. And indeed, there may be other factors that come into play, as we mentioned at the outset, such as part exchange values and so on. And that finding that these are separate commercial roles contradicts in some ways the findings that the consumer would view this transaction as a single transaction. So that's not to say that a dealer cannot assume a responsibility in an individual case. But if they did, well, there may be a dispute of fact as to what happened. And if, for some reason, the dealer overstepped the mark, then the lender wouldn't usually know about that. So last but not least, then the Court of Appeal also said that the lender in this and similar cases undoubtedly knows of the agency relationship giving rise to the fiduciary duty. And again, one thinks back to the case of Branwhite, which was not referred to in the judgment and no doubt will form part of the arguments before the Supreme Court, and the fact that there is no need to attribute an agency to a motor dealer in this scenario. So if one is approaching a transaction in the future pending this decision, then of course we're going to expect there to be a certain amount of diligence to make sure that there's no indication that could be construed as undertakings to source the best or most competitive deal, or that the most appropriate product is being selected. And we're likely to see a raft of disclaimers arising that, for example, brokers are not whole market brokers, other lenders may be available, this is not independent financial advice, we're not your agent, fiduciary advisor, and so on. Did the Court of Appeal go too far? Well, here, if one looks at the two limbs of a fiduciary duty, I've already spoken quite a bit about the undertaking of a role. Here it's even more stark because, of course, the hallmark of fiduciary duty is that the broker is acting only in the interests of the principal, which here is the consumer, and is obliged to subordinate their own interest to that. And quite simply, why would a car dealer subordinate his own interests to that of the customer? And why would a customer be entitled to that level of loyalty? Again, we come back to the opposite ends of a commercial transaction and the artificiality of divorcing the transactions. And on the question of trust and confidence, well, really? We're dealing with second-hand car dealers for the most part, who are up there, as we know, with double glazing salesmen in terms of customer confidence. And so in most cases, it really does seem to be slightly unbelievable, where there is self-serving evidence given to say, well, of course, I trusted the car dealer. And in fact, in cross-examination, that invariably falls apart. So that, of course, is not to say that there can never be a fiduciary duty, but as per the words of Lord Leggatt, high expectations do not give rise to fiduciary duties. And it begs the question of how the car dealer can make a profit, because if they're not allowed, arguably, to make a profit on the finance, because, for example, the customer might not consent to it, then that would effectively mean that they would have to revisit the car sale price, which they cannot do if that contract's been concluded. And so it effectively precludes models which sell the car cheap and make the profit on the commission. And moreover, once the car dealer has switched roles on the Court of Appeal analysis and becomes a fiduciary, well, if, again, they can't make a profit without the customer's consent, that would arguably mean that they can't make a profit on the car without the customer's consent. So they'll arguably then need to explain what the profit on the car was, which is highly unusual and takes us back to square one. So the idea that a car dealer would have to say, well, we bought this car for £10,000 and we're selling it to you for £15,000 is unheard of. So a key issue, of course, is entitlement, and that will no doubt be hashed out before the Supreme Court. The next point is informed consent. This is not a ground of appeal, but briefly merits discussion, because if there is partial disclosure, well, that can be enough in certain situations, and it can mean that there's no breach. And the decision here was surprising because of the extent of the disclosure that the Court of Appeal said was required. So what is enough for informed consent? The short answer is it depends on who the customer is. Of course, we have the idea of a sliding scale in many cases predating this case. It's not new. And usually can be looked at on the spectrum of vulnerability and sophistication. And so, for example, the Court of Appeal contrasted the wealthy, sophisticated investors in the case of Medstead and the vulnerable, unsophisticated borrowers seeking to keep a roof over their heads in Herstanger, where they, of course, the Medstead sophisticated wealthy people did not need to know the amount of the commission, but the unsophisticated Herstanger vulnerable borrowers needed to know the amount of the commission to bring home the extent of the conflict to them. Here, the Court of Appeal said that if Mr. Johnson and again Wrench and Hopcroft were considered to be secret, so they didn't get onto this, had read the suitability document, it would not have informed him that he would, as opposed to might, that commission would, as opposed to might, be paid, let alone the highly significant right of first refusal. He wasn't told the amount, how it was calculated, and there was no warning statement that the dealer was not in a position to give unbiased advice. So that really is quite extensive, and there's, I think, 5 main points following on from that. The Court of Appeal said a lack of informed consent is automatic if there's only partial disclosure. But I would query whether that's necessarily the case. A customer may know the position, and indeed they may be told the position during the sale. So even if the dealer doesn't tell them everything, the customer may know enough. Secondly, on the issue of whether one uses the words "we may pay a commission" or "we will pay a commission," the FCA never precluded the use of the word "may." And indeed, if one gives a purposive interpretation to the rules, as we're required to do under the FCA handbook, arguably saying "may" is enough, because it puts the customer on notice of a commission. And so again in Herstanger, and indeed in the Energy Commission's case of expert tooling and Engie, which has recently come before the Court of Appeal, the High Court didn't think that distinction was important. But the Court of Appeal say in this case that the possibility of a commission is not enough, especially if the circumstances are not defined. Again, the extent of disclosure is highly unusual, because Conk didn't require anything more than the fact of the commission at the time. The amount was on request. And we had the case of Herstanger, which said, okay, well, if they're vulnerable, then you may also need the amount. But here we've moved to amount, model, basis for calculation, any tie, right of first refusal, and a warning that unbiased advice cannot be given. So in some ways, everything is potentially relevant. But again, that is arguably not inconsistent with some of the old case law on sunlight bleaching things in the context of fiduciary duties. Fourthly, what does this do to the relevance of the regulatory regime? It's a shame there's no real discussion of the regulatory regime in Conk in the judgment, because the interplay between the fact of the existence of the regulatory regime and the need for a fiduciary duty, or the extent of a fiduciary duty, is highly relevant and is indeed likely to feature an argument before the Supreme Court. But we have been here before, of course, in a slightly different context, in the case of Plevin, where the Court of Appeal refused the appeal because the touchstone was the standard imposed by the regulatory regime, the ICOB rules in that case. And then when the matter reached the Supreme Court, Lord Sumption said that the ICOB rules was some evidence of what the standard of the commercial conduct reasonably to be expected for the purposes of the unfair relationships test. That led to an intake of breath on the basis that the standard of reasonable commercial conduct is this regulatory standard. It's not just some evidence of the standard, and it's the standard upon which businesses rely. And so that finding is extremely problematic for business certainty. And looking back, businesses designed these systems around what the regulator required. And if one's thinking about Plevin, that was a very specific problem, which doesn't really read across here. As I said a moment ago, Mrs. Plevin was arguably buying a commission because 72%, which is such a high level of the price of her product, was commission. And so that affected her perception of the value for money of what she was buying. But that's not the case here. Customers are clearly told the APR in relation to the agreement. They know the price of the car. They get a car worth the amount of money that they're paying for it, arguably, if they've shopped around properly. And so Plevin, the facts of Plevin don't read across to this scenario. And lastly, where does it leave confidentiality and competition? Because if disclosure to this extent has to be made, well, then presumably the industry will very quickly align, which is bad for competition. So arguably here, the Court of Appeal have again gone too far, because businesses don't generally work to a higher standard than that required by the regulator. And again, back to the forum, we have a comment saying, to be fair, you can see their point. If you go into Tesco, you don't see a tin of beans listing the amounts paid to everyone in the manufacturing chain through to retail. You see the price on the tin. The courts have taken the view that with car finance, you should see who gets what. But actually, in car finance, you do see where the money goes to the extent required by statute, because the Consumer Credit Act requires you to see what is interest, what is charges, and what is credit, and how much those are. And CONC requires commission disclosure where relevant. Lastly, and I can see I'm getting close on time, was the issue of accessory liability. And here the Court of Appeal found that in circumstances where the lender hadn't satisfied itself that the borrower had not given fully informed consent, there was a problem. The submission that the lender required the broker to disclose the commission was meant that there was no dishonesty, was rejected. And dishonesty in this context was said to be knowing or deliberately turning a blind eye to the breach of the broker's fiduciary duty. The clause requiring disclosure didn't assist because it fell a long way short of full disclosure of all material facts. And so the lender, having taken no steps to satisfy itself that the broker had obtained informed consent, was on notice and must have suspected that the customer was not fully informed and deliberately turned a blind eye. Again, this is surprising, that the lender must satisfy itself that the broker has obtained fully informed consent, and that a lack of informed consent is automatic in the case of partial disclosure, and that the only way to be sure is for the lender to make full disclosure itself, and that the lender should preferably get the broker to certify or confirm that informed consent has been given. And so here we're going to lead into real issues around proof as to informed consent having been made moving forward, unless this area of the law changes in the Supreme Court. Have they gone too far? Well, I would contrast in this regard the case of expert tooling in the Commercial Energy Commission's context. There, the judge said, well, attempts to control broker conduct are irrelevant if dishonesty is required. If dishonesty is required, that means there must be dishonest, the lender must have dishonestly persuaded the broker to breach a fiduciary duty or assisted in the breach. And there was no evidence of dishonesty in that case, and therefore they couldn't be an accessory. On whether there was a blind eye, it didn't arise in the context of procuring a breach of fiduciary duty in that case, but it did arise in the context of an implied term. And in that respect, the court and expert tooling and the High Court said, well, a blind eye may equate to an intention to procure a breach of contract, but there is not a sufficient blind eye where the brokerage agreement demands transparency and an ethical approach. And it is not inevitable that the broker will breach the duty. And in that case, there were email assurances of commission disclosure, as indeed there are in many of these cases. And so that is all reasoning which should arguably apply here. That leaves very, very little time to just say very briefly a word on unfair relationships. It's not so much part of the Supreme Court appeal, but it's likely to inform the arguments, and indeed the argument that there's no need for duties because this can all be dealt with under unfair relationships. But in this regard, the Court of Appeal said quite helpfully that there was, to the lending industry, that there was no disclosure. If there was no disclosure, that would not necessarily be sufficient for a finding of unfairness. and that everything would turn on the specific facts. In the Johnson case, it considered the documents to be misleading, and it also considered the percentage of the commission at 25% to be very high, and said that a very high commission can be enough. As I said at the outset, that has a tension with Plevin, because here the decision as to the value for money of the transaction is not affected by the amount of the commission. And so, again, looking at the forum, we have someone called Tarian who says, what is the problem with hidden commission? Surely the end cost to the buyer is the priority. Dealer A tells me the APR is 7%. Dealer B tells me it's 8%. I am sufficiently numerate to confirm the monthly payment in each case is correct. Naturally, I buy the car and finance through Dealer A. Later, I learned Dealer A got £300 commission and Dealer B would have got 200. Knowing the commission amount would not have changed my purchase decision. Aside from curiosity, why should I care? The biggest worry from this court case is the cost of extra compliance in all sorts of businesses. And guess what? Those costs are hidden. So, remedy, lastly, is another point that is going to raise its head in the Supreme Court. The extent of this argument is unclear at present. Helpfully, the Court of Appeal said that where there was partial disclosure, that given the length of time passed and the fact that the car had long been sold, it was not an appropriate case for rescission. But the real problem here, potentially moving forward, is the fully secret cases, to the extent that any of those survive. Because if they do, there will be a requirement, if not in the Supreme Court, then moving forward, to grapple with irreconcilable lines of authority on the entitlement to rescission in law and in equity, issues of valuation, and whether and how one can unwind hire purchase agreements, in particular where the car is no longer available. So we haven't even gotten to limitation. That's not a feature of the case, but again, is a feature in many of these cases, and depending on whether the decision is bad news for lenders, is likely to take on additional significance to try and minimize the exposure. So coming back to where we started, well, not everybody has scrambled to change their disclosures to the extent suggested by the Court of Appeal. And indeed, I was interested to note that indeed Money Saving Expert, where I started, still says that they may generate a payment to the site. If someone clicks through, the link is tracked and may generate a payment to the site. And so one queries whether, in fact, this is the type of thing that could really be said to be hidden in plain sight moving forward. And so there would be some amount of irony if we ended up with the website that has recruited 2.5 million of these complaints to be on the hook itself. So I will park it there. If anyone has any questions, please let me know.
Gosh, thank you so much, Kate. Rarely do we have a whole hour of going through case law. It's absolutely fascinating for us geeks lawyers on the call. Yeah, I mean, you know, I'm not in this space. This doesn't impact me other than personally, I guess, as it probably impacts everyone. But I think it's very clear that the financial kind of impact of this and consumer confidence, it's no wonder that the Treasury and the FCA both wanted to be part of this and intervene in some shape or form. So absolutely fascinating. And I'm guessing that given the kind of impact, there is definitely a sense of needing to expedite this from a Supreme Court perspective. Has there been a date yet? I don't think there's been anything.
It is, there is, yes. It's it begins on the 1st of April. So,
okay, so it is pretty quick.
Exactly. Yes, unusually quick, which shows how well understood the problem is. But the Treasury have been knocked back. And I think that's probably right, certainly from the optics. In some ways, allows the Court of Appeal to make the decision purely on the law, as they're bound to do. And I mean, to a certain extent, presumably the main point for the Treasury is this is a big problem. Well, that point has already been made. And so arguably one can see that that was the right decision by the Supreme Court, and to proceed with the parties that they are proceeding with.
Yeah, fascinating stuff. I'm going to open up, see if anyone's got questions in the last couple of minutes. Everyone's just soaking up all that information.
Yeah, but just to say, an excellent presentation, great summary.
Good.
Of a very, very complicated matter and very topical. Excellent.
Thank you.
Super. Well, thank
you.
We're going to send around. Yeah, we're going to send around your bio and contact details, Kate, if that's okay with you. And then everyone can contact you as needed.
Good. Well, again, thank you for staying awake for an hour of law.
It was fascinating. Fascinating.
Yes. Well, let's see what